Thank you all for being here. I'm Jamie Gillespie, and I am the General Manager for our online dispute resolution product at Tyler. So I see a lot of very familiar faces around here. So for any of you that I don't know, it's nice to meet you, and for all the friends in the audience, I'm glad to see you here. I have a couple of special guests that are going to join me, and they are from the 8th Judicial District Court in Nevada, so I'm going to introduce them. And they'll come up here and they'll stay on the stage with us to kind of talk through this. So Mr. Stephen Gerson is the Court Executive Officer. So if you would come up here. Michael Doan is the Director of IT. And Raeshann Canady is the Family Mediation Center Manager. So she's going to do a lot of the talking with me to help kind of show the perspective from the Mediation Center. So just to kind of start this off, and then I'll kick it over to Steve to kind of get us going. I think that you probably all are familiar with the 8th Judicial District. You may not know it as that because most of us know it as Las Vegas. I like to call it my home away from home, but some people may not go there quite as often as I do. But really what Las Vegas is known for is you have drive-through wedding chapels, you have Elvis impersonators that do your marriages, but there's another side to that because a lot of the people that go through those marriages also end up in divorce and have custody issues. So that's really what we're focusing on here, is how to help those citizens do their custody situations online so that they don't necessarily have to come back into the city and do that work. So I'm going to turn it over to Steve, and he's going to kick it off for us. Mm-hmm.
Thank you, Jamie. Good morning, everyone. Thank you so much to our NACM folks for making this event always possible for our court administrators. Thanks to Tyler Technologies, who have been a stalwart partner for us in our efforts to progress, and for inviting us to talk about our experience with ODR in the 8th Judicial District. The journey that led the 8th District to ODR is no different than many of your courts. With increasing corporate attention to court markets, globalization of technologies, and the national trend towards service improvements through automation, courts are facing a larger important trend that will demand some considerable attention. The value we place on what users are going to demand from our courts and how they want to access our courts. As a result, court administrators and judges are going to face increasing pressure and obligations to evolve. And it's my hope that we can capitalize on these opportunities. As many of you already know, grand systemic changes don't come easy for institutions, especially for our courts. Our rich traditions and relationships to decorum are fundamental to the assurance of justice, fairness, safety, and timely resolution. And I know that timing and places and people are critical to policy decisions that advance and improve our courts. I'm asking that you remember one thing, that citizen-centric access to justice has little or no lobby. We can't forget to view the court from the outside at times. I've never regretted an expense that improves the experience of a court user, like jury chairs that plug into phones and devices, coffee machines, web apps for check-ins, kiosks for jury, IVR for phone check-in, automated court forms, with guided interviews so people can feel heard in their pleadings and we can actually read them. Archiving our records little by little so that they have accessible to people across the country to resolve critical life events and easily find their old court orders. And of course, we have to take a look at the newest kid on the block, ODR. When you get your chance on an improvement for the people, I ask that you take it. The 8th Judicial District Court took it. In the summer of 2017, when I attended an exec forum hosted by Tyler Technologies, ODR was in their sights. At that time, I was focusing much of my attention on improvements to our Family Mediation Center related predominantly to lengthy delays in the returns. We decided to take our shot with the ODR to see if we couldn't find improvements and possibly the opportunity to examine systemic changes in that case type. And I'll let the others talk in detail and tell their story. But I'm very optimistic of ODR's future in the courts, to think that we actually have citizens resolving their child custody issues without any intervention from a mediator, and filing those agreements in court is astounding to me. I spoke with one of our pilot project judges who recently said to me, you know, so far those finishing that ODR thing seem to be a little younger. And not to diminish the importance of the issue, one litigant stated in his court that he was so happy he didn't have to come to the courthouse and could play Fortnite on one device, resolve his child custody issue on the other. Our first completed mediation online without any intervention was the litigants had relocated to Reno, Nevada, which is an 8-hour drive north, and the other litigant, the defendant, was in Elko. So they completed an online mediation, and they were in very distant parts of our state. So this is all about access to justice, and it comes in many forms. For Clark County in Nevada, we've had a great history of court administrators and leadership. Populations were exploding in the 90s, and we were building programs left and right, like family mediation, specialty courts, self-help centers, ADR. In the 2000s, we built the Regional Justice Center and large facilities and added tons of judges. And in the 2010s, I don't even know if that's how you say that, but in the 2010s, my decade, we were all about automation, automation, automation. I have a running joke with my assistant court administrator, Mike Doan, who's in charge of IT, that once you finish the next project, I just don't know if there's going to be anything left for you to do. I actually seriously said that one time about 8 years ago, and I've been eating those words ever since. So to all our great court administrators out there, I implore you to make a list of all the ideas that would make your court a better experience for those that use it. Include the new opportunities with ODR, and keep all those ideas close to you while you make short and long-term plans. Because if you don't, no one else will. Thank you again, Atlanta, and thank you to all the court administration employees out there that move our courts forward each day. Thank you again to NACM for all you do to advance the purpose of this country's critical branch of government. And let me now turn it over to the people who actually make it work. Thank you very much.
Good morning. I have the best part of this this discussion because I'm in charge of IT. So for this product, it's a hosted product, so very little impact to IT. Self-registering, so all of our users can create their own accounts, reset their own passwords, do all that. Very little impact to IT again. And then integrations, standard APIs, so pretty much any product that you have. We do have Tyler's Odyssey case management system, but any other case management system can interact with this. So.
Okay. I don't really like to stand behind a podium. I'm going to fix all my healthy women out there will understand what's going on with this here. But I'm not really a podium person, but I just want to talk really quickly, kind of give you an idea of what Family Mediation Center looks like. I came to the courts about 4 years ago, and one of the reasons was because of the progressive sort of ideology of the court. I was very excited about that, the specialty courts that they had, the treatment courts. And so for me, this is just another tool of progression as a way for us to provide services in an enhanced way. So I have the equivalent of about 11 full-time mediators. I feel that I have a luxury because I know a lot of programs are not sort of in-house or court connected, and ours is. So I know that some of what we talked about and some of what you guys have been hearing about feels like, how am I going to make that work if I have a system where, you know, I have to contract with the mediators or some other system. So I know that that's a struggle. I don't really have that struggle because I have the luxury of having the staff that are available to take care of the cases. And we have cases coming sort of out of the woodworks. In 2017, we closed just shy of 3,900 mediations. And that's just one of the 3 services that we provide. And so for us, ODR has really been sort of an enhancement to our program. What we do is we provide them with an in-person mediation appointment for each of the ODR cases so that there's no additional delay. ODR doesn't delay our cases in any way, but we give them the opportunity to first see if they can work it out themselves online. And so we give them an appointment anywhere from 21 to 28 days after because of the timelines for ODR. And if they aren't able to work it out themselves, we'll talk a little bit about how our pilot works, but we can provide them with assistance online, and if that isn't successful, then we still have the in-person appointment to come in and to help them finalize those details. There are pretty much 5 things that we discuss in our parenting plans. We talk about legal custody, we talk about the timeshare, which is physical custody, the terms around the country, you might hear child time, parenting time, timeshare. We sort of refer to it as timeshare, which is the largest area that parents really struggle with. Vacation, holidays, and exchanges. Overall, for the Family Mediation Center in 2017, our agreement rate was an average of 71%. When we take a look at a little bit of the data, which we will for April and May, because we started our pilot in April, our agreement rates are around that same percentage. We're at about 74%. So we're going to be able to provide you with a little bit of information about the program and how it has affected or enhanced our system in just a moment. So you're going to see a demonstration that will sort of show this presentation a little bit. But essentially what we do is we handle all of the contested child custody cases. In Nevada, by statute and by local rule, the judges send them to mediation automatically when there is disagreement in terms of child custody. We handle other types of mediation cases as well, but for this particular tool, it's for the child custody cases with 2 parties. During our pilot phase, we're allowing them to negotiate online, and there's no charge for that if they are able to resolve those issues themselves. That's one of the incentives for them to sort of get involved and kind of try this new thing out. Once we get involved as a mediator online, or if they need to come into their in-person appointment, then we charge them like we normally would. It's a sliding scale. It's really a nominal fee when you compare it to what private mediators might be charging. So we started a pilot program in April. We used 3 judges. We have 3 staff. I actually am one of those individuals so that I could really have a great understanding of what this tool was all about, so that as we phase in the remaining judges and my staff, I really have a good idea of how to tell them what works and what doesn't work online and how we want to approach this tool. Right now, we give them a pretty short time frame. The interesting thing about this tool is that it can be modified to fit whatever kind of time frames you guys want. Right now, we give the plaintiff 3 days to go on and submit their proposal. We give the defendant 3 days to respond. And then if that doesn't happen, then we automatically will come in to provide them with some assistance.
So I really would like to do a demo, but it's going to take a little bit longer than what we have here. So I'm going to kind of do just a quick overview, but we will have someone that's in the exhibit booth after this that can do a full demo for you so you can see it. So I'm going to kind of start off as the plaintiff or petitioner here, and I have to play a couple different roles, so bear with me. So when the plaintiff or petitioner gets engaged in the process, the first thing we do is we're kind of explaining what this is and how it works. Ray, when she started, mentioned that they cover those 5 areas, but we actually, as we were doing the work and the configuration, we realized that some of those components are a little bit too in-depth to have just one area, so we kind of wanted to split those up because we're really trying to make them in smaller, more consumable pieces so that the parties don't get overwhelmed with the piece, whatever it is that they're working on at that moment. So you can see here that we actually broke it down into 8 different sections. So as the plaintiff is going through this, they are at each of those different images or different categories, they are proposing what they want as their parenting agreement. So they have the opportunity to come in here and really tell us, this is kind of the best case scenario for me. So we are defining what each of those components are, because the terms that we use in the courts is not necessarily the same thing that the parties understand. So we really had to make sure that they understood what each of these components means and what the impact to their children and themselves would be based on the way that they picked. So once we define it, then we kind of give options. And we do have the ability to have a customized option in some of the areas that make sense. But for example, on the legal custody, there really isn't an option other than sole custody or joint custody, so there's not a need for it there. But based on the different components, you'll see kind of different options that are available. So once they select that, we are presenting this back to them, telling them this is the way that it's going to show on your written parenting agreement. And it's just kind of another check. So just, keep doing the checks and balances so they really understand what they are saying and what they are going to end up putting on their proposal for the parenting agreement. So here it is, just kind of presenting that back to them. You can see here, I kind of skipped a few, the vacation and the transportation, and I went to exchanges. So the same concept applies there. We define what exchanges are, we tell them what their options are, and we allow them to select one. And you can actually see this is one where they have the ability to write something customizable if it doesn't fit in the options that are displayed for them already. So here they are filling out the exchanges. So again, based on wherever we are in the process, the questions are going to be different. We're really walking them through this step by step so that they understand what they're doing. I mean, it's important, obviously. I tell people when I'm talking about this that, we are coming up with how they're going to, do their parenting back and forth with their co-parents. And most of the time, my children are my most important things, not always. But, they're working online to generate how this is going to go forward for their children. So once the petitioner does all of their proposal and comes up with what they think is the right scenario, it then goes to the defendant or respondent to do their part. So here is what happens on the defendant's side. So they are presented back the exact same options that the plaintiff selected. So you can see here the example with the legal custody. They are shown that the plaintiff said that this should be joint legal custody. So they have an option to accept that proposal, or they can propose a different legal custody option. If they select to propose something different, they're given all those same options that the plaintiff was given initially. So this is the way it works for each one of those. So as they go through that, once they complete it, it gives them a visualization of where they are in the agreement, like where have they made connections that both parties are agreeing. So you can see here in this example, they've agreed on everything except the legal custody option. So they are allowed to go back and forth, and this is just what we consider our party-to-party negotiation. So these people can continue to go back and forth during that time frame that they have been set up in the system to be able to continue to negotiate. And they can, again, keep proposing different options back and forth until they either come up with an agreement or if they time out, so if they run out of time or select that they want to get a mediator involved, then that's when it would kind of go to the next step. So in this example, I selected that I wanted to get a mediator involved. So once that happens, that's where Ray's team gets involved. And once they get engaged on this case, they quickly see an overview of where we are. So what's going on? Where have the parties agreed? Where are they not in agreement? And you can see on here, and I know it's kind of hard to see all this on the screens, but you can actually see the different, what party one proposed versus what party two did. So you right away at a very quick glance can figure out, hey, where is our starting point here? The mediators have the ability to do opening statements or welcome statements within the system to kind of teach the parties a little bit about what mediation is, just like what they would do if it was in person. But the other thing that is neat about it is they have the capability to not only have joint discussions with the parties, but they can also do private caucusing. Just like, again, if this were in person and they needed to talk to one party outside, they would, have a private caucus with that party. They have that option in the system as well. So they can do the joint caucusing or the private caucusing with each party. Once they get through that entire process, then the system will actually generate the agreement that's then filed back through the court. It's called different things in different jurisdictions. We call it here the parenting agreement, and it's filed back in. The system can either do like a full agreement. It's obviously what the goal is, to get full agreements, but we can also do partial settlements. So in a scenario where the parties can settle on some of the items, but not all of them, we can present that back to the judge. So in court, they can say, okay, I see that you have agreed on 3 of the 5 topics, so we're just going to work on the 2 that you haven't agreed on, and that's what we're going to have the trial about. And it also can do just non-settlement agreements, because surprisingly there are some situations where co-parents can't agree on anything, and it has to go to a trial for the judge to make a ruling there. The system allows for electronic signatures so that each party can review it and do an electronic signature before that's filed back through the court. And then that document is filed back through the court through the e-filing system, which just uses your standard ECF integrations. Does anyone have any questions about that? And we do have time for questions at the end, but that's kind of an overview of the way the system works. And again, we'll have, after this, we'll have someone out in the exhibit booth that can demo it so you can kind of see it up front. Yes. Hang on, she's going to get the microphone.
Good morning. Ray, when you mentioned mediator, you said you, meaning, are you the mediator?
So for the pilot, yes, I'm playing a couple of different roles. I am a mediator as well.
And that's not a conflict with the court?
No.
Okay.
Her role in the court is she runs the mediation center. So
okay.
Yeah. It's kind of a little bit different than.
Did you promote me while I was, am I?
Yes, I sure did.
Okay. I knew I liked you when we met. All right.
All right, so let's kind of talk about the impact that this has had so far and what we're seeing from the end user. So as Race talked about in the beginning, the actual requirement to do mediation on these cases is mandated, but using the tool is not mandated for these courts. It's just another option. So everyone is put into the system, and if they use it, then that's great, and if they don't, then they just come to that in-person mediation appointment that they already have set at the time that the case is referred to the mediation center. So we actually saw 56% of the petitioners participate in that. I don't know how you feel. It's kind of hard to see people out here, but for us, that was a lot higher than what I expected in what we consider a permissive environment. So something that's an option for them, more than half of them engaged in that process and created a proposed parenting agreement for the other party. On the other side, once the petitioner did it, the respondent participation was a little bit lower than what we had seen on the petitioner side, so only about 45% of them actually completed that process to get then engaged back and forth with the negotiation or with the online mediation. And then when you take a look at all of those cases where both parties participated, 46% of them were able to complete an agreement and come to 100% agreement with just between the two parties, so just the party-to-party negotiation without the help of any of the third-party neutrals or anyone else. They came to an agreement. And I'm not getting any excitement here, but y'all, that's really, really exciting. Thank you. I mean, almost half of the people that engaged in this were able to come to an agreement about the way that they were going to share the children with their co-parent. Another 8% came to a full agreement with a mediator. So more than half of them, just through the online tool, were able to not come in, able to cancel that in-person appointment so that they didn't have to come in to that session. And then the other 46%, some of the parties weren't able to come to an agreement on any items, but we did have, if you kind of took all of the components that we have, which are those 8 ones that we showed at the beginning, the other 46% of the people were able to come to an agreement on almost half of those components. So by the time they came into the mediation, there were already some areas that they had agreed on. So those wouldn't have to be necessarily focused on in the mediation. So if you just kind of think about those numbers again, so that 46% where they came to a resolution, 100% online, every one of those in this first 60 days was done outside of core court hours. Every single one of them. So outside of the 8 to 5 time. So to me, there's no better definition of your expanding access to justice than that stat right there. Every single agreement happened outside of the core court hours of 8 to 5. So Saturdays, holidays, 2 in the morning, whatever it is. You know, ODR is something that the court can offer that's different than anything else that they can offer, because, I mean, how many of you have the ability to have your staff working 24/7? Probably not many of you. But this tool allows the parties to engage at any time that's convenient to them. The next thing, and we kind of did talk about this, again, more than half of the people that participated in this were able to come to a full agreement, whether it was either on their own or, again, with a mediator assistant. And then the last one I think I already said too. So the parties, once they did engage, they at least had some part of the items, you know, at least settled, or to a point where once they went to mediation, they kind of have a starting point. So the other thing, if you kind of think about, and these standard, or these numbers may be a little bit different for your jurisdiction, but on average, the court dates are about 2 months or 60 days from the mediation referral, so that's when they have their hearing set. But then, you know, Ray kind of talked about on average, they're doing like 3 to 4 weeks for their in-person mediation appointment. That's when they get that scheduled. But what we saw with ODR is it's actually less than 1 week. So if you take a look at them, the average parenting plan was created within 6 calendar days, not business days. And the fastest one was in 4 days. So again, these are people that are working over the weekends on this, or whatever time is convenient to them. So this really, you know, kind of shows what we're talking about with how important this ODR is with the expansion of access. It's going to make the courts faster because they're able to get these people in. They already have a full agreement, and they can come to court and get that over with and move on. So, Ray?
So one of the things that we've done is get the party feedback about this tool. And so when they have to come into their in-person appointment, we ask them what obstacles or challenges they faced with the online tool that they think prevented them from being able to finalize things online on their own. And so we have a list of things, but we sort of just ask this open-ended question to get feedback from them. And in particular, there have been 2 areas where the parties have felt as though this tool wasn't something that, that they were able to really work with. Most significantly was, right now, it is a tool that they need to have a tablet, a laptop, or a desktop. It's not smartphone friendly at this point. And so for a lot of parties, that is an issue. And then secondly, feeling like they didn't have enough time. So when we get the referral, we initiate the process for them. And because it's new, we also provide them with a little bit of information about what is this, what are the advantages to it, and how is this process going to get started. But they feel like they're a little rushed. And so we have the ability to modify those time frames and modify really a lot about the tool based on the feedback from the parties. So we are going to be moving to providing them with a little bit more time in order to engage with the tool. But those were the 2 areas in particular that the parties provided feedback, and we call them parties in our jurisdiction. They provided feedback about what was helpful and what wasn't necessarily helpful in allowing them to really use the tool to its best abilities.
And the other thing is, after the process, if they're able to complete the agreement completely online so that they are not needing to go into the appointment, there's a survey at the end so we can really get some feedback from the users. So we kind of asked, the first question was, how long did this process take? So we give them 3 options: less than 2 hours, between 2 and 5 hours, or more than 5 hours. So you can see that 67% of the people said less than 2 hours. So that really, again, kind of shows you, especially if you're in a jurisdiction that has high traffic, it's hard to get around from one place to another, maybe it's a larger area. They, you know, potentially parties could be driving for 30 minutes to an hour just to get to an appointment that then they have to mediate. So under 2 hours to be able to do this is pretty nice. The other thing is that we gave them 5 options, and we said, hey, did the tool help in any of these? So we said, did it limit your time away from your family? Did it limit your time away from your work? Did it save you money? Those are 3 of the components. And you'll see that on that, 44% of the people that completed the process said yes for all of those components that did happen. And the other thing was, did we make it easier for you to reach an agreement with your co-parent so that you're not having to be face-to-face with that party? And that was 11%, and then the last one was also 11%. Did this simplify the legal system? Because again, for those of us that are in this day-to-day, we understand the terms, we understand the processes, but for someone who hasn't been involved in this, they don't know what they don't know what pro se or pro per means. They don't know what a self-represented litigant means. They don't know once they complete this, what's the next step. A lot of them don't even probably know what mediation is when they're referred to that. So RAISE team's having to teach them that. So if you kind of think about all of those different things, that's just the feedback that came from those surveys. And then the one thing, we did have a user that gave just a comment, so I wanted to share this. So Pamela said, it's a great offering and effort put forth by Clark County. It's an economical tool for people who are willing to negotiate and compromise. So again, obviously she was one of the ones that was able to complete the agreement online. And for her, it made a financial benefit for her that they were able to do that. All right, so I think we're down to the last little section here, right?
Yeah, so one of the things that we've done with our pilot is we meet on a weekly basis to kind of talk about how this tool has affected our practice. And so we really have kind of honed in on 3 things that really distinguish the online process from the in-person process. So one of the things that we realized that we do is we tend to use a lot more pleasantries in our interactions with the parties online. So when you think about when you get an email, one of the first things you might usually say is, oh, thank you for your response. But in person, if somebody answers a question, I don't always say thank you every time they state something. But we find ourselves doing that a lot more. And it sort of just evolved naturally because we're used to communicating that way in email and online formats. So that's one of the things that we notice, just sort of as an observation. One of the other things that we notice is that this is much more of a reactive process than a proactive process. So when we have the parties in front of us, we have a fairly scripted, for our jurisdiction, we have a fairly scripted introduction that we go through so that we help them understand what mediation is and more importantly what it isn't, what we're going to discuss and what we're going to accomplish. And while we provide that online, we sort of go through these guidelines with them and they check off that, yes, I've read them and I understand them. And we have a little bit of that in our welcome statement. I can't stop somebody mid-type. So once that message comes, it's there, and I have to react to it, as opposed to in person, when I think I know what's coming, I can say, let me just stop you there, Susan, 1 second. And I can prevent all of that from coming out about, I think I should have the kids because he's, the devil himself. I can kind of stop that in person, but online, it's out there. So then you have to react to it. And so you have to kind of do a little bit of damage control. What I think you'll find, and what I'm finding with my team, is those mediators who are a little more, like to be very much in control of the process, this is a challenge for them because of the reactive nature of it. And then your mediators who are a little more go with the flow are going to probably be able to respond to this a little bit better. It's not better or worse, it's not good or bad, it's just different. And we also noticed that giving the parties very tiny bits of information is much more effective. So when we first started, we were treating it, because we just didn't know, we were sort of treating it like we do in person. When they come in, we have probably a 5 to 7 minute introduction where we go through, these are the things that we're going to discuss today, here's what we're going to accomplish. So we give it all to them up front. And then as we go through each section to negotiate, then we kind of break it down. So when we started online, we thought, that's the way we'll do it. We'll send this message that says, we're going to talk about legal custody, and this is what legal custody is, and we're going to talk about this. And people were like, it was like crickets. People were like, what? What's happening here? This is too much information. So now when we get involved, we start with one thing. And generally, each message is no more than 3 sentences. And so it means every time I send a message, they get an email notification. So that means that I'm going to clog up their inbox a little bit with 3 or 4 messages in a clump, but they're much more responsive to that. They can read that message really quickly and respond. They can read the next message and respond. With a large chunk of information, we're sort of losing them. So we try to keep it very small, all the way down to, okay, thank you for your response, Susan. You're proposing Tuesday. What time? Not you're proposing Tuesday through Thursday, what time on Tuesday, what time on Thursday. Very, very small bits, and that seems to be a lot more effective with people in responding.
All right, so at this point, we have time for questions. So are there questions out there? Okay.
Good morning.
Good morning.
Thank you for the presentation. I'm just wondering if you took into consideration when you implemented this, I don't know if you have other languages in your jurisdiction and how that might work with this application.
I'll start, and then maybe they can add to this. So the tool is multilingual. We do have it deployed in French, Dutch, and English already. However, what we have found in the court system in the U.S. is that if we were able to allow the parties to only select those bulleted options, we could then translate that back into English to be filed with the court. But all the places that we have anywhere that they can do a customized solution, there's not any court-approved translation tool that would allow us to translate that and then pass that back into English. So the only way that we're able to do that is if we can make it where there's no places where they can do anything that's customizable. Does that make sense?
So do you refer them through interpretation services, or do you refer them to in-person?
So the way that we're doing our pilot right now is that we're only engaging those individuals who are English speaking. So on our staff, obviously living in the Southwest, we have 3 full-time mediators who are Spanish speaking. So we can handle all of the Spanish speaking parties. We don't need to use interpreters. But for the tool, it's in English. Now, we are having discussions about that because while they may not be able to resolve it completely by themselves without any intervention from a mediator, at least in our jurisdiction, we could get involved at the back end. They've resolved everything, and we just translate it like we normally would. When they come in and they engage in the process in speaking Spanish, our mediator still has to translate that to English and upload the document in English format. So we could still handle it that way. We just started small with our pilot, but we have the capability to include in particular Spanish-speaking parties.
Yes.
Hey, Steve, got a question for you and your colleagues up there. Can you tell us what, if any, court rules you had to change or modify to be able to support this, or if it just fit under your existing system, or if you had to do it through just individual case management orders to sort of adjust and allow for this type of process to happen?
Oh, yeah.
We did it under our current court rule and had the support of the presiding judge to test. Filtering them or vetting them through an online process didn't interfere with any of the rules that we had because we set the appointment. Everything stayed the same on the appointment. If this didn't complete, they would come to the appointment and they would type it up and submit it to the court. So nothing changed on our end with respect to any of the rules. We just added this front layer on to see how it would impact the court, and we kept it really small. You know, I've been in Kevin Bowling's wake for 10 years, and he said, keep it small, keep it, you know, it takes a while, you don't know exactly where you're going, and that's why we took the presiding judge and a couple of other judges and said, can we filter some of these cases through to see does it even work? I mean, what's happening to this? So, no rule changes, and we're just doing it under the current law and the rules in our court.
So do you see rolling out of that pilot phase, you know, just for benefit of other folks here, saying, are there rules that you think could be helpful to then sort of memorialize that, institutionalize that, to give a program like this the support it needs to be something that's got some life to it?
Yeah, so the strategy to roll it out to the whole district will be, we have to bring it before the judges now to decide on the policy decision on the whole program. So we wanted to keep it small. We wanted to learn about it so that when we present it, they're going to have to vote to make this a part of the actual protocol, and we'll discuss, do we need rules for them, for all the parties. So we have another rollout phase. We don't know exactly when it's going to happen, but I anticipate in 2019 that they'll decide, and then we'll have to fashion all the rules around that. So thanks.
Will, I think there's another question here. Where?
So based on the statistics that you provided in your slide, are they system generated? Like, are you all able to run reports and show us how many people reached agreements, or is that something you had to do?
Good question. So for some of the statistics, for example, that there was generated agreements, 100% agreements, those are all system-generated reports that can be run. When I talked about them all being done outside of court hours, I was actually looking at the time when the agreements happened, so that one was something we did manually. But for the other ones that were in there, those were generated by the system.
Okay, and then I'm sorry, I have like 2 more questions. Okay. For mediators, when the parties are unable to reach an agreement and I guess an email goes out to you that says unable to reach an agreement, are your mediators on call? Like, do they get that email at 2 o'clock in the morning? And if so, how long do they have to respond?
No, right now we have it during our hours. So the Family Mediation Center has extended hours. We're open from 7 a.m. to 6 p.m. So we sort of go beyond the court hours, but no, they don't get an email at 2 in the morning. I like that idea.
Well, they get the email at 2.
Yeah, they get the email, but it goes to their work email, and they're not expected at this point to respond to that. And so, but one of the things that I think a tool like this can do is you have the option or the ability, depending on your jurisdiction, to look at flexible hours like that. So one of the questions that came up with my staff is, well, basically, does this mean we're going to be out of a job? Is that what this is intended to do, is to replace us? I don't see that happening. I see this as an enhancement. I see it as an additional tool for certain people. Not every party is going to like this format. Or are going to be able to agree online. There are still a percentage of people who are going to need that in-person interaction. But they get the email on their work email, and then they respond as soon as they can. And so one of the things that we did find in our pilot, we were giving the plaintiff 3 days, the defendant 3 days, and then we were giving the mediator a day once they timed out, once that email was sent, to send the welcome statement. And so because this is accessible to the parties 24/7, we were sometimes getting that email on a Monday when I have flexible scheduling for my staff, or on a Sunday at midnight. And so what we are looking at in terms of modifying is giving the parties a little bit more time, but then also that welcome statement can be automatically generated. And so then the next time that the mediator comes into work, they can respond. But at least they've had some contact with the parties. The parties have received that message saying, hey, I know that you need help. Let me take a look at your activity online, and then I'm going to engage with you guys. But they're not expected to respond unless they're at work.
Yeah.
And last question, how do you protect the integrity of the system? Because parties are coming to agreement online. So what happens if I have my ex-husband's password and I log in and I agree to something that he would not have agreed to?
Yeah.
And then I go on my account and I agree too.
Yeah. So we do get that question that comes up sometimes. So first of all, when people are showing up in court, at least in our jurisdiction, we don't card them. We don't expect them to give us their DNA or their fingerprint. We don't know who these people are. We don't know who they are when they're showing up for the mediation appointment. If you say you're John Jackson, all right, come on back, let's talk. I don't really know who you are. So there's a little bit of that in person too. Somehow we feel a little more secure when they're coming in, but there really is no additional assurances when they're in person. So yes, is it possible that somebody could have the other party's password and go in and agree to something? Certainly, but here's where we have our stopgap. So first of all, we have our in-person appointment. So John Jackson is gonna show up, and I'm gonna say, well, you guys agreed online. And he's gonna say, no, I didn't. Boom, right there. We've got our first issue, right? Or let's say that John Jackson doesn't show up for the in-person, but he's going to show up in court, and the judge is going to say, so I hear that you guys have made an agreement. No, I didn't. Where's that coming from? And the other party's going to have to explain some things. There's going to be some splaining, right? So there's a part where you have these measures set up where if that's what's going on, then we're going to be able to figure that out pretty quickly, and the other party's going to have to answer for that to the court.
I think we might have time for one more question if there's any more out there. All right, I don't see any more. Oh, I'm sorry, in the back. Okay.
Sorry, can you briefly walk us through sort of what the case initiation looks like? So, right now, the old way is come in the courthouse, you pay your filing fee, you file your papers, you have the other party served. what's it look like now with ODR?
Okay, so the three pilot judges, our judges send us referrals in different ways, but I'll just speak to our pilot. Our three judges are fairly traditional in the sense of having the parties come in for an initial hearing before the referral. They make the referral to us, the parties come to us because we're located inside the courthouse, and we schedule our in-person appointment with them. We also provide them with the information about ODR. That same day, we initiate the ODR process. So they're going to get an email within 24 hours of them coming in and scheduling their in-person appointment. And then they have that period of time, which is generally, I think our time frame right now is 15 days to work on it. And if they don't, they still have that in-person appointment.
And from the, ODR really can be used in multiple areas in the system. It can be used before a court case is even filed. But as we've kind of walked around and talked to the people across the U.S., people really are uncomfortable with that. They want it to be, they want to have a case number within the court. So the way that we're doing this right now is cases are filed with the clerk. They have a case number and everything's been paid just like what it would be if there was no ODR at all. And ODR is just kind of stuck in the middle of the process that is kind of a waiting period for them to have their in-person appointment and mediation or their court appearance. So it's not something that typically had anything else going on. So it's kind of, we just put it into that process however the time would work out for them. Okay, so there's one more question, but I think we're out of time. So we'll be at the booth, well, at least I will. I don't know if they'll come with me, but over there. So thank y'all for your time today.
Thank you.